In Texas, child custody is based on the best interests of the child. The court usually recommends mediation, but in some cases mediation doesn't resolve all issues surrounding child custody. Here's everything you need to know about child custody in Texas. Understanding conservatorship. In Texas, the term for custody is conservatorship. The child's custodian is the conservator. The court decides the terms of the conservatorship based on what's in the best interests of the child. There are two types of conservatorships in Texas. These include joint managing conservatorship, or JMC, and sole managing conservatorship, SMC. Child visitation. Child visitation is considered possession of or access to a child. In most situations, the judge will allow both parents to have access to and possession of their child. If the judge feels a parent poses a physical or emotional threat to the child, he or she may deny visitation rights. Using certain guidelines, the judge will issue a standard possession schedule. Parents have the right to agree on a visitation schedule. If they can't agree, the judge will order a schedule for the parents to follow. Best interests. In Texas, the court makes decisions for custody based on the best interests of the child. Joint legal custody is the standard unless one parent can offer proof otherwise. The court considers many factors, including the history between the parent and child, the state of the relationship between the parent and child, the parent's place of residence, the health of each parent, and more. The court tries to ensure continuing contact with both parents as long as it's in the best interest of the child. Texas courts encourage parents to work together to raise their children. Parents must adhere to the child custody order. If one parent denies access to the child, the other parent has the right to bring the issue before the court. Third-party custody. In some situations, a third party may attempt to gain custody of a child. If a parent is deceased, a close relative can file a custody suit. If the child has been living with someone other than the biological parents for 6 months or more, the child's caretaker may file for custody. Grandparents have legal rights and may file suit if the parents are deceased or unfit. If both parents have passed away, the court may grant custody to one or both grandparents. In any custody situation, you need an experienced family law attorney to protect your rights and the rights of the child in question. Child support. Under a joint managing conservatorship, the primary conservator provides residence for the child for the majority of the week. Typically, the child spends time with the other parent for a designated period during the week. In most cases, the parent who doesn't have primary conservatorship pays child support. The amount depends on the parent's income and the number of children in question. Parents with similar income levels may be jointly responsible for the care of the child. The court can modify child support payments if it deems the amount unfair for either party. If you're facing a child custody issue or a problem with your current agreement, you need the guidance of an experienced family law attorney. Child custody cases can be emotional and complex, and it's important to have an attorney who understands the family court system and will fight aggressively for the outcome you deserve. We'd love to talk with you and help you find the right path ahead for you and your child. Contact us today to discuss your case. And if you found this video helpful, be sure to like, comment, and subscribe.